Welcome to Clause 8, the voice of IP. Clause 8 is part of IP Watchdog and sponsored by Harity, the go-to firm for the Patent 300 for patent preparation and prosecution. And if you enjoyed this podcast, tell your friends you heard from us, and please leave a 5-star rating wherever you're listening now. And now, here's your host, Eli Mazer.
Today, we're lucky to be joined by Lillian Shaked, all the way from Israel. She has worked on more patent transactions than any other person on the planet, and she's currently the VP at Trans-Pacific IP and has her own law firm in Israel. So Lillian and I, we actually met at an IP Watchdog conference, and I got to know your story a little bit. Obviously, a very interesting story about how you ended up in the patent space, but you were somewhat modest about your background. And then I learned she's actually worked with a who's who in the patent monetization space and has a lot of interesting stories. So I knew I had to have you on the Clause 8 podcast. So thank you so much for joining.
My pleasure. Happy to be here.
So before we talk about how corporate attorney in Israel became such a significant player in the patent space, I wanted to talk to you about how you ended up in Israel. So you were born in Canada. What made you move to Israel?
I guess Zionism. I'm Jewish, so I wanted to live in the land of the Jews, and I was very fortunate. I came to Israel, I went to law school, and I started in high tech, which was just starting. So I really got a boom for my career, as high tech law in Israel is all practiced in English. I had a big advantage, and so I basically made a career in corporate and commercial law in Israel with the combination of my English-speaking skills and my local education.
Do you remember when you first learned about patents?
I do remember when I was on a marketing trip for the big law firm that I was a partner at, and was put in touch with one of the more well-known patent assertion people, and was asked to help with the transaction in which patents would be acquired out of Israel, and that's why I was approached.
Before you were asked to work on this, you had zero experience with patents up to that point?
I had experience with IP. Being a corporate commercial attorney, I had a lot of experience with licensing of technology. High tech in Israel involves a lot of licensing of technology, as well as a lot of high tech company representation and venture capital fund representation. So certainly the issue of IP and patents in terms of protecting technology was something that I was very familiar with. But in terms of commercializing through monetization, through licensing and litigation was something that was new to me.
The client you were presenting was actually the patent assertion entity that was based in the U.S., is that correct?
That's right.
Can you tell us a little bit about that company in Israel that was able to build a portfolio that interested this patent assertion entity in the United States?
So we're going way back before so it was actually a single inventor with just a small number of patents. It was certainly not a very big company with a huge portfolio of patents. But there were a couple of interesting patents. I believe there was a broker involved in the transaction then, and my client recognized value and, again, approached me in order to acquire the patents for licensing purposes in the U.S. Most Israeli companies and inventors, even if they are local, begin by starting with prosecution in the U.S. So even though you're dealing with Israeli companies or Israeli inventors, in the end, you're dealing with U.S. patents.
Is there anything, I guess, that you remember from that deal that you learned going forward?
Absolutely. Other than being hit on the head a number of times from the client, whom I grew to like over the years and have another interesting story about that, and my ability to make a career out of that one deal, that initial deal, which we should get to. The idea that different from a normal asset transaction or an M&A deal, where there is not a potentially ongoing relationship between the buyer and the seller, patent acquisitions should be a more friendly transaction. Oftentimes, there's what's called a back-end relationship, where the seller eventually might receive a portion of the proceeds generated by the patent.
And that was true at the time as well?
That was true at the time as well, yeah. And so both parties have an incentive, if you will, to ensure that the transaction documents are written the way they should in order to provide the buyer standing position to the extent that he or she or they want to litigate. It shouldn't be too onerous. And since there might be an ongoing relationship, especially if the patents are being purchased from the inventor and the inventor might need to be assisting the buyer in licensing, there's generally a more amicable atmosphere, and the transactions are usually done in good faith. Negotiations should be positive, whereas if you're doing M&A, and I was doing M&A beforehand, that's not always the case.
So that's interesting to hear, but I imagine like you were obviously representing the buyer who has experience doing a lot of these transactions in the past versus the seller who is this independent inventor who might be the only time he's ever done that, and he might be kind of concerned about being taken advantage of or not foreseeing what he should. Did you see that come into play? A hesitancy to take a yes for an answer from the seller's perspective?
Again, inventors have an incentive to do deals of this type simply because it means that in another situation in which the patents would just be, a nice certificate on the wall and sitting on the shelf, this actually gives them an opportunity to utilize the patents to the extent that they're not used for commercializing products or technology. And so they have an incentive to see the patents move over to somebody who can make money and gain respect for the inventor if the patents are in fact licensed. So, and again, the deal terms are not necessarily that complicated through negotiations, through discussions. It's certainly possible to explain to the inventors the provisions of the agreement in order to reach a win-win situation.
Do you mind sharing who that patent buyer was? Because you mentioned you ended up making a career out of it. So who was that patent buyer? And I guess how did you guys end up forming such a positive relationship in the long term?
It's Eric Spangenberg. And the company was called IP Navigation Group. And Eric, both for himself and for his then wife, acquired many, many patents for their own companies. But then he actually set up a patent monetization company whereby he provided monetization services for third-party clients. And I basically did all the acquisition and then the licensing of all the patents that all of his clients acquired. And the reason I was able to make a career out of it was that I got along quite well with Eric, not always, but most of the time. Some other people did not. He worked with a lot of people over the number of years that I worked with him, and if things didn't go well, these other people would leave to start up their own businesses, and they remembered me. So for one client, I ended up with many, many clients who were well-known in the space.
What do you think made you stand out to him? Obviously at some point he was a very well-known entity. I'm sure there's a lot of ambitious patent transaction attorneys who wanted to work with him. I guess what made you kind of want to work with you? What do you think
maybe being that far away from him physically, having thousands of kilometers between us and a different time zone. But I think one of the things that has helped me in my career is the fact that being originally from Canada, obviously, I'm able to communicate, read, write, and draft in English, but I have a 7-hour time advantage. So clients send me work at close of business in the U.S., and it's back in their inbox in the morning when they arrive at work. And Sunday's a work day here, so I'm able to offer these services, whereas local people might struggle with that a little bit more.
So that's interesting. The fact that you were actually in a different time zone, you think that actually kind of helped you? Did it cause any difficulties in terms of they want to have an in-person meeting the next day or something like that? Did you come across any of those kind of issues?
No, I think the hardest thing was just the licensing transactions that I did with several very well-known companies on the West Coast and just the time difference there. It was often negotiations at night on licensing agreements. But in terms of working with the clients, it was never an issue.
Interesting. So obviously, Eric Spangenberg, who I did know you worked with, he's been written about in the New York Times. He's had pretty significant profile. He was called in that profile, I think, by a critic, one of the most notorious patent trolls in America. You kind of entered this space. Did you have any kind of feelings about what a patent troll is or what the role of a company like IPNav was?
No, and that could be because of my history representing startup companies and technology companies and inventors, and knowing the importance of intellectual property and the right to enforce intellectual property. And without the ability to enforce, there's no incentive to create. And we were careful, and there was no ankle biting. There was no sort of trying to enforce patents that we weren't convinced that there was actual infringement and that the patents were good patents. And a lot of work, time, resources, and effort was put in to making sure that the claims in the patents and the elements in the claims matched those of the infringing product. So I'm just not sure where the idea of patent troll came up, and as a result of whom or which company or what patents. The ability to enforce valid intellectual property, I don't think is something that should be looked down upon.
There is a narrative that before, in the wild, wild west days of maybe early 2000s, that people were just enforcing these really bad patents. From your perspective, you were actually working on these deals for one of the most significant monetization player at the time. It seems you cared about things like validity and infringement, and you weren't, even back then, it would have been a waste of time to try to enforce bad patents. What did you learn from working with him? Obviously, he had experience at that point. What did you learn, in addition to the things that you mentioned about being in this space?
Other than sort of the more technical aspects and the legal aspects, patience and relationships. And we would acquire patents and license the same entities over and over again. And that brings up another story that I have. We would license the same entities. And once you do one deal, you do two deals, you do three deals, and they see that you're coming with good work product, high quality work product, and you've done your research and you've done the work and you've been negotiating reasonably, then it then becomes much easier to continue to work with these people. If you're going to sort of burn your bridges and be nasty, even if you get one deal done and you get a couple more cents on the dollar, you have to consider that these big players are the ones you're going to come up against a second time and a third time. And if you're not able to maintain relationships, it becomes much more difficult.
So the importance of not trying to get, like you said, every cent out of a deal, but really building these long-term relationships obviously has a big return long-term. So that's important. I mean, you've worked with a lot of other names. Is there anything, I guess, the kind of you see the different approaches with different players had, and anything in different styles or how they approach the work?
Eric's model and IP Navigation's model has always been to try to soft license, so to try to initiate discussions and conversations with potential licensees prior to filing, whereas other clients I have file first and talk second.
The model that Eric had has become much more difficult right now because there's always a risk now that you try to soft license these days. They'll just try to go to a favorable venue and then, they'll never want to kind of negotiate with you. Have you seen that having to move away from that soft licensing model?
Well, the risk of DJ was always there, declaratory judgment. That risk was always there. But it goes back to what I said before about relationships and building relationships and trying to understand that it could potentially be a win-win to soft license before filing. And again, if you're working with the same companies and sometimes even the same people in the same companies, and you have a history, both about your ability to pull the trigger, such as in Eric's case, but the fact that you're reasonable and you've done your homework, then it is still possible to soft license. And there are still a number of patent assertion entities out there that soft license first. And especially in the realm of SEPs, where it's a requirement to initiate discussions prior to filing. So I don't think that model is dead.
That's interesting. Even from a perspective of licensee, it's also good for them to build those long-term positive relationships. because if you're a serious player, we'll probably see you over and over again, unless they're ready to spend more money trying to, on litigation and so forth. It probably doesn't make sense to have this confrontational relationship.
Correct. Although there are certain entities that doesn't matter what, until hell freezes over, they are going to fight and they're going to not be willing to talk to you.
Can you talk a little bit about that? Let's say you're working at one of the patent monetization player like IPNav, and they have to make a decision. We have these 3 companies that are all infringing our patents. We know that one of these companies is reasonable and they'll probably work with us and reach a reasonable deal. This other company is not. It's probably going to go all the way to Supreme Court before they give us assent. I mean, how does that come into play about who do you approach and how do you approach them? How do you think about the strategy from that standpoint?
Sure. Again, it's an interesting question, and oftentimes you'll talk with the partners or the potential licensees that you've dealt with in the past and are willing to discuss with you. And it can end up being a win-win situation because you reach a deal earlier on. Sometimes you're able to negotiate down a licensing amount. Pressure is then put on that company's competitors, and other side that you're dealing with sees that as a positive thing. If you're going to now pressure their competitors, and in the end, if you have a valid patent and you can prove infringement, you're going to get there anyhow. So you might as well start off with an easier first timer, and then work on the rest. So absolutely, these are things that are taken into consideration.
Let's say a company does have a reputation for playing, we could say, hardball. How do you try to take that history into account? Do you think, well, maybe this time will be different? Or do you kind of know what you're getting into when you're approaching one of these more difficult players?
You generally know what you're getting into. Sometimes people and companies change, which is also an interesting thing to happen. And there might be a company where you've never been able to get an amicable deal with them, and then all of a sudden the head of licensing leaves, the CIPO leaves, and somebody replaces them, and all of a sudden it's a different ballgame.
We mentioned, obviously, how the market has changed over the years. In the early 2000s, you heard about these huge deals all the time. I think I actually saw a presentation from you where you said between 2012 to 2014, patent sales dropped by 84% in dollars and 60% in the number of patents sold. So you saw a huge correction taking place. During those boom years in the early 2000s, the parties that you presented, did they expect that something like that would happen? What was the thinking at the time?
No, absolutely not. Nobody expected it. Nobody, expected the AIA to come into play. The decisions by the courts believed that, big tech wanted to sort of put a stop to enforcing patents and put a lot of pressure on government. And this came out as a result. And there were a miserable few years there, very lean. It was hard to stay afloat.
You worked about this long-term relationship that you had after, let's say, the AIA passed or Alice happened. Did you see these long-term relationships kind of change because of these companies started to think, well, I can maybe easily invalidate these patents and I don't have to pay these licensing fees? Did you kind of see that happen?
To a certain extent, yeah. But since then, since things are sort of a little bit more back on track, generally, patent assertion is happening with bigger portfolios. Nobody would ever take upon themselves a one patent deal and assert one patent. So again, there's sort of more comfort in numbers. So once we're licensing again, we're reestablishing relationships.
I see. So it kind of changed what was marketable, but you kind of had to figure that out during those lean years.
Absolutely.
One of the things that we did see, I guess, is the rise of a role of patent litigation funding as well. And I'm guessing kind of took more money. Well, it took more money to kind of monetize these patent portfolios. And maybe because the economy was kind of has been booming until recently, there was more money to be invested in that. I mean, how did that change your work as mainly as a patent transactions attorney, the fact that was patent litigation funding available?
I think it brought the industry back into business, basically. It became very expensive to acquire portfolios because, as I said, it was no longer sort of single patent deals. You had to find bigger portfolios. It was much harder to find patents, so oftentimes you had to use a broker, what you might not have had to do beforehand, which added cost to the equation. The time to license, I mean, in the heyday, we were acquiring and licensing within 90 days without litigation.
Wow.
90 days from acquisition to license, money in the bank. That sort of became extended to 3 to 5 years. So it became more expensive, a lot more litigation. So if the litigation funding companies had not stepped in to provide the funding, I don't think the industry would have been able to get back on its feet. This has enabled individuals to continue to assert and license patents.
Have you been seeing a change in terms of the patent litigation funding that's available? Even from experiences, it seemed like a hot area, but maybe some of these patent litigation funders learned some hard lessons, or funding is drying up. Have you seen any of that?
I've seen another big change in the space. Originally, the patent litigation funding companies were very passive. They waited for the deals to come to them. They funded companies. They didn't necessarily have a history with the companies. They funded companies. Then there became sort of a misalignment of interests between what the company wanted to obtain in terms of revenue, settlement and licensing revenue, and what the funds thought they were entitled to and what should have happened by now. So they moved from a very passive role to a more active role, where some of the patent litigation funds are actually scouting, looking for deals themselves, working with the same people over and over again. So basically finding the patents, sourcing the patents, and then sourcing the management team to actually manage the assertion. So they've taken a more direct role as opposed to a more indirect role, and that we've seen over the last couple of years.
I'm just thinking of an example off the top of my head. An operating company might want to settle for much less than a litigation funder is interested in, because they have other interests in play, potential relationship that they have with this licensee. Is that the kind of thing that you're talking about?
It was actually different, where the patent assertion entity felt that if they held on a little bit more and held out for a little bit more, they would get more. And the patent litigation fund said, enough, we've put enough money into this.
Oh, interesting.
We believe this is the best you're going to get. You should really take it. And they had no control over the decision making. But oftentimes it's sort of like gambling. The longer you stay in, the higher the risk is, and not necessarily the reward.
Somewhat surprised to hear that, because you'd think these patent litigation funders, they're putting in a lot of different bets. And you'd think patent assertion entity, they might have a smaller pool of bets and they don't want to be more eager to settle. I mean, why do you think that was, that kind of a patent assertion entities?
I tell you, I've met inventors who are sure that their invention is just like the invention of sliced bread. Everybody thinks that their patents are just remarkable, infallible, that they have the best thing in the world, and they just need to get their day in court, and everybody will know that, and they'll line up to pay licensing fees. And that's often a problem. Even now, when I meet with clients and I say, okay, you're interested in selling your patents, how much do you want for them? And they'll just throw out these astronomical numbers, and I'm like, no, sorry, that's just not going to work. And so we saw a lot of that.
It really goes back to the kind of the inventor, the patent owner, because they have an investment in it. And even if you tell them these stories about the PTAB, what can happen in the courts, the federal circuit, they think they're kind of a unique situation where they're going to be the outlier, right? Is that the kind of...
That's right.
You mentioned SEPs. I came across an interesting article that you wrote in 2019 about 10 essential patent owners, about what they need to do to kind of strike more deals with startups and small businesses. My question is, since you wrote that article, have you been seeing more of that, or is that still like a difficult area for patent owners to kind of figure out how to do?
Well, in terms of big companies, it's difficult, and there hasn't been much of a change, and that's predominantly because you often have we'll call them your tech licensing people, very separate from your patent licensing people, and your sort of patent team very separate from your business development and your corporate relations team, whereas I was able to bridge the gap, and I work in both fields. Generally speaking, you have this differentiation. So you might be talking to somebody on the corporate development side for a technology deal, and there's no connect to the fact that there are SEPs in the patent bank and that we can combine the two because you're just dealing with different people in different departments.
I see. So really the idea is not to go out looking for every startup that might be using the technology that you have patented, but really the idea is if you're already forming that relationship, that should be kind of part of the conversation is the underlying technology that you have.
Correct.
Another thing that I saw that was interesting in that article is you mentioned that you want to bring in a transactional lawyer versus maybe a litigation counsel to kind of make those deals happen. Do you have any stories about, I guess, somebody who might come from more a litigation background about something they've done that kind of, or a perspective that they might be missing versus what it's like to maybe do a licensing deal at the end of a long litigation versus building those long-term relationships?
Well, a couple things. Often ego is a big, and without insulting any of the patent litigators who might be listening, but there's sort of the need to win in court, whereas transactional lawyers, the win is getting the deal done. So it's a little bit of a different outlook in terms of the actual negotiations. Oftentimes, litigators are sort of working hourly or on contingency, and they're interested in the highest settlement they could potentially reach. Transactional lawyers might not have that hanging over their heads. And again, it's the relationship building, and oftentimes clients use different patent litigators for different matters, whereas transactional, I work with the same clients regardless of the patents and the cases. So I have more relations with the licensees.
Bottom line is you kind of have a view that a win-win, repeated win-wins with licensees versus for a patent litigation attorney, that might be more difficult to view things that way.
Right. And for transactional, it's like the quicker we get to a license, the better for everybody. I think litigation is a little bit different in that respect.
You mentioned that, these licensing deals that you see that the terms usually aren't that complicated. I mean, what are the kind of terms that you do worry about or pay special attention to when you're negotiating either purchasing patents or licensing patents? Is there anything that kind of sticks out to you?
Sure. When you're purchasing patents, standing issues are very important. So I worked on a case a number of years ago that was clouding software that we purchased patents. And the buyer was a little nervous first time they were doing the deal and wanted to make sure that they had some form of control and they were in the loop and they could, terminate the deal if it wasn't going well. And negotiating with this large company, it was necessary to give them more, I won't call it control, but a little bit more involvement going forward. And this caused a big issue in court because the defendants were able to claim that clouding didn't have standing because it didn't acquire substantial rights in the patent because of all these sort of limitations from the seller. And so without standing, the case was dismissed. So we actually had to go back to the seller and say, look, it's up to you, but we can't file and proceed with this case. So we had to renegotiate the acquisition. So it was made perfectly clear that clouding had full rights to the patents and therefore standing. And this was something that to this day, every time I negotiate a patent acquisition agreement and there are sort of rights that remain with the seller that are problematic, I can see them as problematic because I see these transactions through from beginning to end. So I know and I'm able to explain to sellers why there are certain provisions that are problematic in the acquisition because I already know what's going to come up in the litigation. And further, because I do the licensing and the settlement work at the end, I already know what the buyer is going to have to give to the licensee, and will then require it back to back from the seller. So these are sort of some of the things that if you don't see the entire process, you're not always aware of what you have to take into consideration when you're just starting a deal.
More from a license, when you're licensing the patents, actually, in any kind of terms that stick out to you.
Yes. So if I talked about standing in the patent acquisition side, there's the issue of exhaustion and the licensing side. And oftentimes you have, you're dealing with technology that can be embedded into systems. And you have to be very careful when you're dealing with systems that you don't reach sort of a situation of exhaustion, where it turns out there are products that end up being licensed, even though you did not do a deal with the actual seller of the system, but rather with a specific entity as the licensee. So you have to be careful with systems when you're dealing with components, licensing components. You have to deal with things such as M&A activity of the licensee. So if the licensee, you've done a deal, flat sum, licensee gets acquired by a big player. Well, you didn't intend that the license you granted would cover all of the products of the big player that acquired the licensee, even though it has now become an affiliate of the licensee.
Even though you might have given a more favorable terms to a smaller player, you wouldn't have done that for a bigger player, right?
Well, again, it's based on market numbers, right?
Yeah.
But oftentimes when you're doing a license agreement, you're licensing the licensee and its affiliates.
Right. Yeah.
So you have to be aware of these things.
So this is actually a question that your colleague, Brett Close, he had. Have you seen deals that go sideways? And do you have any stories about what you've done to kind of save those deals?
Oh, sure. There have been deals that have gone sideways, for sure. There have been deals where you start licensing negotiations and the other side becomes difficult, or you don't reach agreement, and then the litigation continues.
What do you think makes like a licensee become difficult? You know, it seems like they're negotiating in good faith, and then is it a personnel change, or is it what's ours a relationship?
I don't think it's necessarily a personal matter. I mean, things happen within the litigation that at a certain point in time, they might be more willing to do a deal, and then they get a favorable decision in court, and they say, no, not worth it for us. Or things like affiliates come up, and if the company gets acquired by a bigger company, and will the license pass on or not, and under what terms? And we have done royalty deals. I've done royalty deals where it's like per unit royalties or based on revenues. And, you ask for reporting requirements, and you ask for audit rights. And these are kind of the things that can lead to deciding that, no, in the end, they don't want to do a deal. Or, for instance, if there's a client of mine that has affiliates who also have patents, do we have to do an entire license agreement that will cover all of the patents of all the affiliates or not? What if the client acquires patents in the future? Are those patents going to be licensed or not going to be licensed? What about a covenant not to sue as opposed to a license? Is it the same as a license, et cetera, et cetera? So there are a lot of issues that come up. Generally, if the parties are going to reach a deal or not. But again, I wouldn't say it's personal.
Have you learned anything about, making sure that a transaction stays on track? You mentioned, for example, there unexpected things can come up during litigation. I mean, is there anything that you can do if you're involved in the transaction to make sure that it gets resolved?
Absolutely. Be quick. Don't wait on things. Like, you have to keep the momentum. You have to turn things daily. You have to be in touch. You have to set up the next call when you're on the first call. You have to keep people engaged.
And how do you know if the other side is not just playing you or trying to buy more time?
Their best interest is to play me and to take as much time as they want. But the pressure of having to get it done, and the setting up the calls, and the exchanging of drafts, and the turning quickly, they can't really ignore that because everybody has a boss in the end.
Good advice. I'm sure you've seen, for example, like the BlackBerry deal, right? Which was, for these days, a big deal, $600 million. And then even an experienced company like BlackBerry, for some reason, couldn't get it done. I mean, is there anything that you look at that and see like, well, they should have done this differently? Or obviously it's a kind of somewhat of a unique situation, but Any thoughts about a big deal like that?
Look, I would not do conditional deals where things are conditioned on funding.
I see.
Either you have the funding or not. I don't think it's the right way to go to announce a deal, not necessarily have the funding in place, hoping that the funding will come into place. Just go out and get the funding. Do the deal when you have the funding.
Okay. So it seems like it wasn't a deal yet. It was a hope that there would be a deal if you don't have funding.
It was an option to do a deal, I think. A better way of explaining it.
So I know you mentioned to me that actually you've went from being a licensing attorney, kind of representing some of these monetization players, to kind of being involved in monetization yourself. Can you talk about what made you kind of go in that direction, and how did you kind of identify that the portfolios that you want to work with?
I've always wanted to be more involved in the actual monetization itself. I was never wary of sort of the term patent troll or patent assertion entity. I never, again, thought of it as, in a negative light. I thought it would be more interesting. I actually did not spend very much time in court throughout my career, and I was interested in that aspect as well. So, yes, I've always wanted to be in that space. In this particular circumstance, I had the opportunity to work with somebody who was acquiring a vast number of portfolios and used the opportunity to say, hey, let me work on some. Let me monetize some. Put together a group, and we took it over.
Have you discovered anything new by being on playing this different role now that you have than just being an attorney who was working on these transactions?
It's a much slower process. I work very quickly. As I said, it's a much slower process, yeah.
You mean it's slower because before you were brought in basically when the deals were about to happen, and now you kind of have to be involved from beginning to end?
Yeah, I think that's probably a good way to describe it. The diligence, I was usually brought in. I would do what I call the legal diligence on a patent portfolio that was up for sale. So I would check encumbrances, and I would check chain of title and the sort of more technical legal issues. The technical due diligence, the actual technology due diligence, the claim charting, et cetera, can be time-consuming, especially if reverse engineering needs to be done. So that's where I find it's a little bit lengthier a process than just the, if you will, the legal side of things, the legal transactional side of things.
Somebody might be listening to this who's in-house, somehow involved in building a patent portfolio, and they say, I want to make sure that the patents that I get are high quality, that, somebody who's in the patent monetization field would want to acquire, and they'd go through due diligence. Any advice based on what you've seen about what makes a valuable patent portfolio these days?
Well, first of all, you have to be very careful and technical and read the documentation and make sure the assignee's name is correct and the chain of title is kept up. And you really have to be diligent to have everything in place, because oftentimes when we're doing diligence and we're looking for documentation, it's not to be found, and all of a sudden somebody finds something and it was misspelled, and the name wasn't the right name, and it was an affiliated entity, and et cetera, et cetera. And these are things that just cause the diligence to drag out. So again, you have to be careful. You have to be diligent with the work that you're doing. There's always a trade-off with patent prosecution, because on the one hand, you have a better chance of receiving a patent if you add that extra element that makes, your invention unique. But if it becomes too unique and too specified, then you run the risk that in the future, there are not other companies that are in fact using or creating products based on your patent. That's something that I always think that patent prosecutors should keep in mind, to try to be as general as possible, but still have the opportunity to obtain the patent.
It is difficult trade-off. The common, obviously, the advice that patent prosecution attorneys give is to keep those families alive, to try to get a wide variety of coverage and all that. Is there anything else that kind of sticks out to you about strategies for acquiring valuable patents, maybe in terms of, the prosecution history?
Geographics. I can tell you that don't just prosecute in the U.S. Make sure you have foreign counterparts. Germany has become, a great venue for patent assertion. Brazil is an up-and-coming venue for patent assertion. So, make sure you have counterparts in good locations. China was going to be a a great location for patent assertion, given the whole COVID affair, etc. It's not quite as hot as it was, but hopefully when China opens up again, it will be back in the bid for litigation. So make sure that you have taken into consideration foreign counterparts in good jurisdictions.
There's a big debate, I guess, in the U.S. now about transparency. And there's this allegation that these parties or this company that is suing, but there's some funders behind it, and they don't reveal who these funders are. Two questions. One is, why does a company that's, let's say, is a true funder of a litigation, why do they set up some third-party company to actually do a monetization of a specific portfolio or a bundle of portfolios? Why is that a part of the business?
Well, again, I think, unfortunately, patent assertion has negative connotations. And, I mean, they're investment companies. They want to make money for their investors. It's a business as is any other business. And I think there's this issue of shaming. And the patent funding companies don't want to take the risk of shaming. But, again, I don't understand this bit about shaming. I always liken patent monetization or litigation to trespassing. You know, you have a piece of land, and in order to get to the other side, people have to walk over that land. Well, you wouldn't tolerate that. You wouldn't allow somebody to walk over your land to get to somewhere else, without giving that person permission. Same thing. People should not use other people's patented technology without permission, without a license. So I don't understand this bit about shaming and the negative connotations, but I do think that patent litigation funds are concerned and don't want to be involved in that. And I think it also comes down to deeper pockets. I think that if you're litigating with some of the bigger companies and they know that on the other side they're able to reach a large patent litigation fund, well, gloves off. Let's do it. Let's require them to be part of the litigation. If things go sour, we have somebody to recoup from. We can, ask for our counsel fees. We can claim damages, whatever. So I think that's where it comes from. And I don't agree with it. It's a business model as is any other, an investment. It's simply an investment.
You personally don't have any issue with revealing who the funders are, but those funders shouldn't be, held responsible for what the entity does in terms of, let's say, paying the other side's attorney fees or something like that.
Yeah, again, it's a business model. The same way that if you were going to fight with a startup company, I don't think automatically you would try to have the venture capital fund that invested be a party and be liable for the company's whatever the company did or damages or et cetera. I mean, oftentimes you'll sue the directors directly, and the directors might be from the venture capital funds, but you certainly wouldn't expect the venture capital funds to be indispensable parties to that litigation.
That's a very, very interesting analogy. I think it makes sense. A few final questions, but one, somebody's listening to this and thinks your practice is fascinating, monetizing and being kind of involved in that, making those win-win transactions. What advice would you give to somebody who wants to become the next Lillian Shaked?
Oh boy. Meet people. Go out and meet people. Read a lot. Read about the issues. As I said, standing issues. Read about patent exhaustion issues. Read about, it's not so much about the technology or the actual patents themselves, but how the business works. Who are the people involved in the business? What are they looking for? How can you add value? I was able to add value because I knew a lot of people and I put people together. I'm always surprised at these conferences that two people that I know, who I assume know each other, do not. So I feel perfectly free to go and introduce them. So the more people you know, the better chance you have of success.
Well, thank you so much for coming on the Clause 8 podcast. I really appreciated talking with you and learning about your experience in the patent monetization field.
Sure. It was my pleasure. Thanks for having me.
Thank you for listening to Clause 8. If you enjoyed this episode, please share it with others and leave a 5-star rating. I'd also like to thank my firm, Harity and Harity LLP for their generous support. Clause 8 is produced by Great Feeling Studios and Brick Brewer. For more information, visit voiceofip.com. Thanks for listening.